Good afternoon. This is John Howard, Interim Chair of the Public Service Commission, and I call this special session of the Public Service Commission to order. Secretary Phillips, are there any changes to the final agenda?
There are no changes.
Thank you. But before we get started, we'd like to note our arrangements for session today. In line with the guidelines concerning social distancing and minimizing large gatherings in light of previous executive orders that suspended provisions of the open meetings law on an emergency basis, we are conducting today's session remotely. I'd like to remind those who are participating by phone to please mute their lines except when they are speaking. The public will have an opportunity to listen to the session on the department's webcast page, and we will also record and transcribe the session for future review. These arrangements have been reviewed by our general counsel and has found that they have meet the requirements of the executive orders. Before moving to the agenda, I'd like to conduct a roll call of the commissioners, and if you could please confirm you're with us when I call your name. Commissioner Diane Berman.
I am here, thank you.
Commissioner James Alisi.
Hello, I'm here.
Commissioner Tracy Edwards.
Good afternoon, I'm here.
Thank you very much. So our first item for discussion is item 301, case 19E0730, as it relates to the joint proposal on the proposed transfer of the Indian Point from Entergy affiliates to Holtec affiliates. It'll be presented today by John Sipos, Deputy General Counsel, Jeff Hogan, Acting Director of Office of Accounting and Audits and Finance, and Bridget Feimeyer, our Utility Supervisor, along with Ryan Coyne, Assistant Counsel, will be available for questions. With that, Councilor Sipos, would you begin your presentation?
Yes. Good afternoon, Chair Howard, Commissioner Berman, Commissioner Alisi, and Commissioner Edwards. The staff of the Department of Public Service appreciates this opportunity to discuss this proceeding, support the party's April 14, 2021 joint proposal, and to answer questions. The joint proposal here fairly resolves the issues presented in the proceeding and includes several financial assurance, oversight, and reporting provisions that, in the staff's view, advance the public interest in this Public Service Law Section 70 proceeding. This case concerns the proposed transfer of the corporate ownership interests in the Indian Point facilities and associated assets and obligations from Entergy affiliates to Holtec affiliates. The joint petition requested that the Commission not exercise jurisdiction over the proposed transfer, or in the alternative, that the Commission review and approve the joint petition pursuant to Public Service Law Section 70. The Indian Point facilities and site are currently owned and operated by Entergy entities. And by way of background, the federal government authorized the siting and the construction of the first Indian Point reactor in 1958. The third and last reactor retired earlier this year on April 30. If the proposed ownership transfer is approved, Holtec petitioner here, which is called Nuclear Asset Management Company, LLC, or NAMCO for short, will not operate nuclear power reactors. It will, however, operate Indian Point's fuel pools and support systems, as well as the on-site independent spent fuel storage installation, also known by the acronym ISFSI. And that facility houses the spent nuclear fuel in dry storage casks. Compliance with federal regulatory requirements, NAMCO and its corporate affiliates, and I'll generally refer to them collectively here as Holtec, will also decommission the facilities and site, move all nuclear spent fuel from the spent fuel pools to dry cask storage, maintain and secure the independent spent fuel storage installation, until the used nuclear fuel is removed from the site. And it will also undertake and complete site restoration activities. So those are, in short, the rules of the road that go along with ownership. Turning to the proposed transfer transaction before the commission today, the petition details a proposed two-part transaction that is scheduled to occur by the end of this month, May 2021. The first part is an internal reorganization and transfer inside the Entergy corporate umbrella, involving the transfer of Indian Point and other assets and liabilities from Entergy Nuclear Indian Point 2 LLC and Entergy Nuclear Indian Point 3 LLC to two limited liability companies whose membership interests will ultimately be owned by an entity referred to as Merchant Properties LLC, which is another limited liability corporation. In the transaction's second phase, the membership interests in Merchant Properties will be transferred to NAMCO, a wholly owned subsidiary of Holtec International. The transaction would thus result in NAMCO indirectly owning Indian Point and the related assets and liabilities formerly owned by the Entergy entities. NAMCO would then subsequently merge with Merchant Properties, resulting in NAMCO directly owning Holtec Indian Point 2 LLC and Holtec Indian Point 3 LLC. Holtec International will thus indirectly own Indian Point and its related assets through this chain of wholly owned subsidiaries. Holtec International also indirectly owns Holtec Decommissioning International LLC, which I'll also refer to as HDI, which jointly owns as a majority owner Comprehensive Decommissioning International LLC, or CDI. And the minority owner of CDI is SNC-Lavalin Group through its subsidiary, Kent's USA Inc. If the transaction is approved and completed, HDI would manage the decommissioning operation with CDI acting as the general contractor. And under this arrangement, Holtec projects that it could obtain partial site release from the United States Nuclear Regulatory Commission, or NRC, by 2036, or possibly as early as 2033. In short, Holtec has stated that it would follow what is known as a DECON, that's D-E-C-O-N, schedule. Alternatively, if the transaction is not completed, Entergy has announced its intention to follow a deferred decommissioning schedule, also known by the industry term SAFSTOR, S-A-F-S-T-O-R, under which the NRC would allow Entergy up to 60 years, or until 2081, to decommission the site. And I'd like to note here and explain the term that I just referenced, partial site release. That's a concept that involves the NRC releasing a portion of the site, and in this case, it would be a larger portion of the site for unrestricted use, but maintaining restrictions and NRC regulatory authority over the smaller portion of the site containing the independent spent fuel storage installation and dry cask storage site that holds the spent nuclear fuel until that fuel is removed under the auspices of the Federal Department of Energy. Now, in addition to the proceeding before the New York State Public Service Commission, there was another proceeding before the Nuclear Regulatory Commission. And that proceeding was in addition to this Public Service Law Section 70 proceeding. Before the Nuclear Regulatory Commission, Entergy and Holtec also applied to that federal agency for authorization to transfer the federal operating licenses that were issued pursuant to the Atomic Energy Act from Entergy to the Holtec entities. The state of New York, represented by the Office of the Attorney General, submitted a request to participate in that federal proceeding and requested a hearing. And at the same time, Holtec requested that the NRC provide an exemption from a federal regulation limiting the purpose for which money from the decommissioning trust, or trust, I should say, may be used. Ultimately, both NRC staff and 3 NRC commissioners granted the exemption, denied the state's intervention petition and request for hearing, and granted the transfer of the federal licenses from the Entergy entities to the Holtec entities. The state of New York, represented by the Attorney General's office, the Village of Buchanan, the Town of Cortland, the Hendrick Hudson School District, and Riverkeeper filed petitions for judicial review of that NRC action. And those petitions for review are pending today. I'm going to turn back now to the public Section 70 proceeding. During 2020, the Commission received public comments about the Public Service Law Section 70 proceeding and the proposed transfer of ownership interest. The Commission heard roughly 7 hours of oral testimony at 2 virtual public statement hearings held on February 23rd, 2021. On the same day, DPS staff from the Office of Accounting, Audits, and Finance reviewed Holtec International financial statements brought to DPS staff by Holtec International representatives. And throughout the proceeding, DPS staff also continued to engage in informal written discovery with the petitioners. And during the course of the proceeding, DPS staff served and petitioners responded to 35 separate information requests. More recently, following exploratory discussions, DPS staff filed a notice of impending settlement negotiations on March 19, 2021, informing the parties that the issues presented in this proceeding might be amenable to settlement and that negotiations would commence on March 24, 2021. Those negotiations did commence. All parties participated in the ensuing negotiations, and those negotiations culminated with the filing of the April 14, 2021 joint proposal. I'd like to just briefly summarize the joint proposal. It was agreed to by all parties, and it establishes multiple financial assurance mechanisms intended to ensure that the new corporate owners maintain sufficient funds to comply with the legal obligations associated with owning and operating the site and to complete those obligations. The joint proposal also contains oversight and reporting provisions to provide the Commission, department staff, New York State, and the public with information needed to properly oversee those attendant obligations and responsibilities, and includes other provisions designed to protect the public's interest in Indian Point's thorough and prompt decommissioning and site restoration, as well as the responsible management and security of its spent nuclear fuel.
Excuse me,
Yes, Becky.
you are trailing off just a little bit. Just the last few seconds wasn't able to pick up.
Would you like me to repeat that?
Please.
I'd be happy to. I'll go back to the joint proposal contains oversight and reporting provisions to provide the Commission, DPS, New York State, and the public with information needed to properly oversee those attendant obligations and responsibilities. And it includes other provisions designed to protect the public's interest in Indian Point's thorough and prompt decommissioning and site restoration, as well as the responsible management and security of its spent nuclear fuel. How am I doing, Becky? Is that better?
Yes, very much. Thank you.
Thank you. Just wanted to check. There are 3 types of financial assurance conditions here: minimum trust balances, DOE litigation recoveries, and third-party surety guarantees. And specifically, the joint proposal establishes a series of minimum balances that Holtec must maintain in the decommissioning trust funds over time. First, Holtec has agreed to maintain a minimum balance of no less than $400 million in the trust funds until at least 2031. After 2031, Holtec has further agreed to maintain a minimum balance of no less than $360 million until it has obtained partial site release from the NRC, the concept we discussed previously. And finally, because the independent spent fuel storage installation and its dry storage casks and spent fuel will remain on site following partial site release, Holtec has also agreed to maintain a minimum balance of an amount to be determined based on projected remaining costs after partial site release until the spent fuel is removed from the site and the as-if-C is decommissioned and the site is fully restored. Now, as an additional financial assurance, Holtec must return and deposit at least 50% of any spent fuel management reimbursement. Start that again. As an additional financial assurance, Holtec must return and deposit at least 50% of any spent fuel management reimbursements obtained from the United States Department of Energy to a dedicated subaccount until Holtec obtains partial site release. If the fund's collective balance is ever projected to fall below the required minimum balance, Holtec must first use DOE recoveries other than those deposited in the dedicated subaccount to replenish the funds. Only if additional funding is still needed to achieve the required minimum balance may Holtec rely on the recoveries in the segregated subaccount. Additional financial assurance is further provided under an administrative consent order executed by both the New York State Department of Environmental Conservation and Holtec. Under that administrative consent order, Holtec has committed to conducting comprehensive site investigations, characterization, remediation, and restoration activities for non-radiological waste and other contaminants at Indian Point. Moreover, in the administrative consent order, there is an acknowledgement, and it further requires Holtec to remediate residual radioactivity below the Nuclear Regulatory Commission's 25 millirem per year standard, and instead achieve the New York State guidance of 10 millirem per year. To ensure that funds are available to complete this work, Holtec will secure third-party financial assurance in the amount of $110 million that names DEC as the beneficiary. Additionally, Holtec will obtain a $30 million pollution liability insurance policy that would offset costs arising from previously unknown releases of hazardous substances. The joint proposal also establishes a series of reporting requirements with which Holtec must comply. First, Holtec has agreed to meet monthly with state and local representatives to provide project updates. And at these meetings, Holtec will report on, among other topics, the status of major project activities, the project budget, and any significant changes to either the project schedule or projected costs. New York State will also receive twice yearly updates on the status of the decommissioning trust funds. Both reports will be accompanied by in-person meetings between New York State representatives and Holtec executives to review their contents. Finally, in addition to these financial assurance and reporting provisions, the joint proposal addresses a variety of other concerns. It requires, for example, that Holtec notify DPS staff and the owners of the natural gas pipelines located on site before undertaking certain decommissioning activities. Holtec is also required to promptly notify DPS staff of any nuclear emergency, fatal accident, serious security threat, or media event should one occur during the course of decommissioning. And it incorporates a memorandum of understanding between Holtec and the local governments in which Holtec commits to honor Entergy's previous payment in lieu of taxes agreement, and which establishes a process for negotiating future pilot agreements. It also covers payments to emergency planning agencies. The joint proposal also includes an agreement among the parties that they will promptly withdraw all litigation within 10 days related to the NRC license amendment and transfer proceeding. That was the litigation I mentioned earlier. From staff's perspective, the joint proposal fairly resolves all concerns regarding the Public Service Law Section 70 petition. DPS staff recommend that the commission approve the joint proposal. First, the record indicates that the Holtec entities appear to possess the financial wherewithal needed to decommission the site, as well as to restore the site under the auspices of DEC. Under the proposed transfer, Holtec would take custody of the decommissioning trust funds, which had a collective balance of more than $2.4 billion as of December 31st, 2020. That sum exceeds Holtec's projected decommissioning costs, even before accounting for the projected DOE reimbursements, half of which will be deposited back into the trust funds until partial site release. Additionally, DPS staff have reviewed several years of Holtec International's audited financial statements, and the information contained therein indicates that the company is financially sound. Most importantly, the joint proposal includes multiple financial assurance provisions that apply regardless of Holtec International's financial health and that protect the public's interest in ensuring that Holtec does not exhaust the trust funds before it completes the decommissioning and site restoration work. The various minimum balances will ensure that the funds remain well capitalized until certain significant project milestones are achieved. These balances are, moreover, backed by a dedicated revenue stream in the form of future DOE recoveries related to the breach of contract claims. Finally, Holtec's site restoration obligations under the DEC Administrative Consent Order are further secured by other third-party financial assurance instruments. And therefore, in light of the trust fund's current balances, as secured by the joint proposal's various financial assurance provisions, DPS staff find that the Holtec entities possess the financial wherewithal necessary to responsibly assume ownership of the site. Second, based on DPS staff review and the information gained so far, Holtec appears competent and capable of managing spent nuclear fuel and decommissioning the site. Holtec has experience in the Holtec has experience in the field of spent nuclear fuel management and has previously worked at Indian Point under a contract with Entergy. The established working relationship between Holtec and Entergy should assist in a smooth transition. Holtec has furthermore been approved by the NRC to decommission two other nuclear facilities, Oyster Creek Nuclear Generating Station in New Jersey and Pilgrim Nuclear Power Station in Massachusetts. DPS staff review of those projects has determined that while both projects remain in the early stage of decommissioning, they appear thus far to be proceeding on schedule and in line with Holtec's projected budgets. With these decommissioning projects commencing some years in advance of Indian Point, New York stands to benefit from the experience gained and the lessons learned at Oyster Creek and Pilgrim. DPS staff find that Holtec possesses the necessary technical capabilities and experience with spent fuel management to decommission and restore the Indian Point site. Finally, several other factors favor commission approval of the joint proposal. First, Holtec intends to complete the decommissioning obligations decades faster than Entergy would under NRC's deferred, safe stored decommissioning approach. Under the joint proposal, Holtec has committed, absent a force majeure event, to transferring all spent fuel to the independent spent fuel storage installation dry casks no later than December 31st, 2024. After that, Holtec projects that all work except the ISIFC decommissioning will be completed by 2036, possibly as early as 2033. Again, this window is far shorter than the permissible window for Entergy's preferred safe store decommissioning approach, which could leave the site unrestored and sitting idle for up to 60 years. In other words, until 2081, if not later. Second, the joint proposal augments meaningful New York State oversight of the project. New York State representatives will receive monthly project updates and semi-annual reports on the decommissioning fund's status. This will complement PSC's regulatory tools already included in the Public Service Law. Holtec has agreed to create a public website that will house public documents related to the decommissioning work. And I should also note that the joint proposal acknowledges the impending establishment of a decommissioning oversight board. Although the establishment of the board is not within the scope of this proceeding, I note that the department is working to organize and stand up the decommissioning oversight board and expects to have that process completed during coming weeks, and indeed is working on it even today. So, in conclusion, for the reasons I've discussed, DPS staff submits that the joint proposal strikes a fair balance between ratepayer and business interests, meaningfully advances the state's policy goal of a prompt and thorough decommissioning and site restoration of Indian Point, and represents a compromise among multiple parties that have often been adverse to one another over the previous many years. DPS staff therefore respectfully recommends that the commission approve the joint proposal in its entirety. This concludes staff's presentation. Jeff Hogan, Bridget Freimeyer, Ryan Coyne, and I are available for questions. Thank you very much.
Thank you, John. I really do appreciate it. Could you describe the differences between the initial petition by Holtec and Entergy to what this order outlines?
Yes, the baseline, the initial petition was what I would characterize as a straight transfer. The ownership interests would pass from Entergy to the Holtec entities without much more. And what the joint proposal has brought to the table, has brought to the commission today, is the additional financial assurance, is the additional financial reporting requirements. There, from a public interest perspective, there's the aspect of the DEC oversight of site restoration. There is the recovery of claims from the breach of the federal contract, which is known as the standard contract. There's recovery under those breach of contract claims. 50% of that comes back to a segregated account. There is acknowledgments about additional use of DOE recoveries should the need arise. There has been recognition of the role or the interest, the role and the interest that the local governmental entities have, as well as the emergency planning agencies, both at a state and local level. So the what was initially proposed, the baseline proposal was I would say it was very straightforward. There were really not the conditions that DPS staff thought was important to protect the new owner, to ensure that the new owner could comply with the rules of the road, with the legal obligations that go along with ownership. So those are I think those are my top topics that reflect the differences between what the commission got in late 2019 and what is in the joint proposal from April 2021.
So absent this action that we hope to take today, we would have to rely exclusively on the federal government and the Nuclear Regulatory Commission for assurances, both financial and managerial, throughout this entire process?
I believe that is correct. Yes. And also along the way, as I noted, the federal government through the NRC granted an exemption from a longstanding federal regulation that limits the scope of projects that decommissioning trust funds could be used for. And the NRC authorized the use of the decommissioning trusts for spent fuel management purposes. And again, the spent fuel management costs are a result of a action, or actually an inaction on the part of another federal agency, that being the Department of Energy, who has not taken possession of the spent nuclear fuel at any point and at other sites around the country. So that was a complicating factor, and one that I think in the joint proposal that the parties were able to have present to the commission today to address that, to address the consequences of that exemption.
Was it safe to say that the other parties involved in this petition and signed on were skeptical of the federal government's assurances to date?
I believe, given the fact that the Office of the Attorney General had pursued litigation options, as had the local governments and Riverkeeper, I believe that would be, that would indicate that they had concerns about what the nuclear regulatory staff and commission had done, over in the federal proceeding. Again, the federal proceeding is separate from the proceeding here, but there was, I believe there was concern on the part of those petitioners, those litigants.
Now, could you elaborate for myself and my other commissioners the timeline for the removal of the spent nuclear fuel from the Indian Point site?
Yes, I could speak to that. In short, it will likely be years. And by way of background, when the federal government first authorized the operation of the Indian Point sites and other sites around the country, such as Vermont Yankee, it told the host communities that the spent fuel would not remain on site for a long period of time. In actuality, it told the host communities that the spent fuel would be removed promptly. That has not occurred for a number of reasons. I'm sure everyone at this meeting is aware, and there have been a number of projections, or I should say predictions, as to when the federal government would pick up the waste. Some of that was spoken to over the course of several years, several decades, in the so-called waste confidence, quote unquote, regulation. But those deadlines came and those deadlines went, and the federal government still has not been able to pick up the spent nuclear fuel. It is likely that the fuel will remain for many years. I recall there was a proposal back in, I believe, 2012 or 2013, that there might be an initiative by 2021 for a pilot interim storage facility. We are now in 2021, and that has not occurred yet. So a long time. That's the whole, that ties into the concept of the partial release that we talked about earlier. The waste, the spent nuclear fuel is likely to remain in the dry concrete storage casks for several years, for many years into the future.
So the decommissioning plan as outlined by Holtec in their application to the NRC is completely decoupled from any potential timeline on spent fuel removal off the site?
The Holtec is projecting that we will pick up fuel over the timeline of the next 40 years. But that is a projection, that is a prediction. You know, one could say, one would hope that past is not prologue. It could very well be on this topic.
Okay, thank you. I guess I have a couple of questions now, probably for Jeff Hogan. Jeff, you know, can you describe the current status of the decommissioning trust funds, and are they now hedged and are put in more secure instruments than they previously were now that in anticipation of active decommissioning work?
Sure. The decommissioning funds, as John mentioned, have over $2.4 billion invested in them. And these trust funds typically have a mix of investments, equity and debt. But as you get closer and closer to the decommissioning time, the trustees of such funds and the investment managers of such funds generally what we call de-risk and slowly increase the amount of fixed income securities that are being invested in and lowering the amount of equity that's invested in because of to decrease the volatility in the fund. So that's been going on, but you know, what's critical here is that when the funds are transferred over to Holtec, the funds will be transferred. There'll be the same trustees and investment managers involved, and Holtec has stated to us a plan for an overwhelming amount of fixed income securities to be in the plans, and those fixed income securities will be laddered. What that means is essentially that they will have maturities that should match the expected spending of the plan. So we do believe that, you know, it's a really safe fund, and that there's a two reports per year that we're going to receive. There's both the NRC report, which comes out and it has to be provided in March, but this order also includes an extra report each August where we'll be told the balances, a breakdown of what investments are, what withdrawals have occurred, and we'll have in-person meetings with Holtec personnel to discuss the plan. So there's a gradual de-risking that's been going on with these funds, but we expect it to be, you know, nearly complete when Holtec takes over in terms of being, I don't want to get into specifics because we met in camera to review a lot of their plans and their financial information, but we expect an overwhelming amount to be fixed income securities.
To that review, which I know you can speak to probably the form, but certainly not the substance, that your review is critical to the staff's determination that Holtec would have financial wherewithal to complete the decommissioning as outlined. Could you elaborate on how we came to that conclusion?
Sure. So we did that was indeed critical to this decision. As John mentioned, that we believe that there's financial security with Holtec. So staff's initial review began with some discovery requests looking for financial information. We were provided some summary financial metrics. The company was, this isn't unusual especially for private companies, was reluctant to provide too much in writing to us. So what we ended up doing was in February, staff met with Holtec in person to review the company's financial statements. They provided financial statements audited 2017 through 2019, and at the time, the 2020 was unaudited, but we reviewed those as well. We reviewed the income statements, balance sheets, cash flow statements, the accompanying notes. There were voluminous notes regarding all of their financial statements. We asked many questions of Holtec at this time of their financial personnel regarding the company's business practices, its approach to financial issues, and other related issues. And through all of that effort, we concluded that that Holtec would be a financially secure company in terms of dealing with the trust fund.
And was this, and you make reference to a private company, that Holtec is not a private, publicly held company, meaning that its financials are less transparent by nature than it would be if it was a publicly traded company?
That is correct. It is less transparent due to that nature.
Okay, thank you very much. That's all I have for my questions. I have a few comments. When I joined this commission in 2019, the then chair Rhodes asked me what items of interest I was most interested in. And without hesitation, I told him that the issues surrounding the sale of the Indian Point nuclear facilities to Holtec and their plans for decommissioning was first on my agenda. And to that end, within the first 6 weeks of my tenure, I visited the plant and heard from the Holtec and Entergy staff directly on their plans. The concept of decommissioning by a new owner and third-party rapid decommissioning is a new concept for here in New York. In fact, this is only the third such transaction of this nature in the entire country. I must admit, I was quite skeptical of the original proposals. The issues surrounding the past corporate practices of both Holtec and its partner, SC and Lavalin, were troubling, to say the least. And the NRC, I believed, did and continues to do an inadequate job on this and many other issues surrounding the nuclear industry. My skepticism was not at all allayed by the NRC staff and the three commissioners who imposed no conditions whatsoever on the transfer of the federal licenses. And in fact, went out of their way to squelch New York's request for a hearing so these proposals could be vetted in public. And additionally, a numerous number of granting of exemptions from existing federal regulations. Clearly at the time, I believed there could and had to be a better outcome. And to that end, DPS staff, along with other parties, pushed for a far superior proposal that would adequately protect New Yorkers in a variety of ways of potential flaws in the original proposal by Entergy and Holtec. I believe that today's order allays my skepticism and provides a continued and financial and operational oversight by New York State that will be necessary to guarantee the public interests are met. The DPS staff and other parties negotiated financial assurances and reporting conditions to address and augment the corporate transfer of ownership interest. They also recognized that the DEC will oversee the actual site restoration of the property, and including financial assuredness to that end. And after reviewing the parties' joint proposals and financial insurance and reporting conditions, I now feel comfortable in supporting the joint proposal and its conditions. However, we should recognize that the corporate transfer here is a first of the kind initiative. And going forward, I will remain cautious and vigilant about the implementation and the parties' compliance with today's order. I'd like to provide an additional observation that's separate and apart from the transaction the Commission is doing today. Even with a successful decommissioning and site restoration of the Indian Point plants, the failure of the federal government's statutory and contractual duties to accept the disposal of thousands of pounds of spent nuclear fuel result in this highly radioactive material remaining on site for many years. In fact, I wrote Department of Energy Secretary Granholm a letter last month asking her what New York could expect in terms of the movement of the spent fuel from all of our nuclear facilities. To date, I have not received an answer. I truly believe the federal government has an obligation to this community and communities across the nation that as long as the spent fuel remains on site, the communities need to be compensated for that. Because as long as the nuclear material is on site, the full value and hopes of what this site could be will never be realized. To that end, I note that Senator Gillibrand has introduced legislation that would aid communities that will be host to these de facto long-term high-level nuclear waste facilities. And I urge the Congress to take action as quickly as possible. Finally, I just want to say what this item is and what it is not. It is not a referendum on nuclear power, its benefits, or its liabilities. Rather, its sole focus on the transfer of the ownership of the Indian Point facility from Entergy to Holtec and the issues surrounding the decommissioning of this plant as described by a potential new owner. To that end, I'd like to make one more observation. In my 4 decades of public service, I don't think I've ever seen better performance by a group of people in support of the public interest. I am very proud of all of those involved, and I would like to take this opportunity to thank them personally. From the Office of the Attorney General, Deputy Bureau Chief Lisa Burianic, Assisting Attorneys Jessica Talent, and Channing Windsor Star Jones. From the Department of Environmental Conservation, Mark Sanza, Andrew Giglionelli, and Commissioner Basil Sagos. From our DPS staff, Deputy Counsel John Sipos, Utility Supervisor Bridget Freimeyer, Financial Analyst Mike Gustel, Auditor Mike O'Neill, Acting Director Jeff Hogan, and Assistant Counsel Brian Coyne. Congratulations. I'd also be remiss if I did not mention the decades-long work of our Executive Deputy Tom Congdon, who has been shepherding DPS efforts for many years. And his position keeps going on. And again, Tom, thank you for the work that you have done. With that, I would like to turn it over to my fellow commissioners for any comments that they may have. Commissioner Berman.
Thank you so much. Can you hear me?
Yes, we can.
Great. So first, before going specifically into Indian Point, I do want to take a moment to thank you, Interim Chair. This special session was properly and timely noticed, not just on the date, time, and place, but what was on this session. It is addressing items that could not wait till the regular June session. And you could have done this through a one commissioner order, but instead you chose to have this special session, giving the entire commission body the opportunity to weigh in and shape the decisions. I personally appreciate your thoughtful leadership in ensuring this was done to include the full commission body, so thank you. As to the Indian Point matter, we are approving, as you know, the joint proposal of this matter concerning transfer of Indian Point facilities, site, spent nuclear fuel, and remedial trust funds. As the order shows, we believe we have jurisdiction over this proposed transaction, and the order reasonably sets forth that we are consistent with prior orders approving lightened regulation in general and specific for Entergy affiliates. The order reconfirms our continued regulatory interest over funding for decommissioning and site restoration. In fact, the order expressly makes clear the importance of ensuring proper funding for decommissioning, site restoration, and emergency response capabilities after a reactor ceases operations. This order is limited to those transfer issues before us that show the transfer is in the public interest and leaves aside those other issues about closure of Indian Point and other perhaps thornier energy grid impacts. Here we determine Holtec possesses the financial strength and technical qualifications to responsibly assume ownership of the Indian Point site and decommissioning it. Rigorous public oversight mechanisms are appropriately built into the order to properly monitor Holtec activities going forward, and I will be voting in favor of this item. Thank you.
Thank you. Commissioner Alisi. Commissioner, I believe you're still on mute.
Hello. Hello.
Hello, Commissioner.
Okay, thank you. This seems to be a muting pandemic. I need to start as both you and everyone else has started by thanking and noting the incredible amount of coordination that has gone into this from so many various parties that come at this from different angles, and how amazingly we have come to this joint proposal. So kudos to all involved. John Typos, thank you for the good report. It's a reflection of that coordinated effort. I will be supporting this because I think that it provides significant financial assurance and reporting. It secures appropriate removal of spent fuel, expedites the overall decommissioning and restoration of the site itself in a manner that is in the best interests of the general public. So a great job, an amazing job, and one that will serve us very well as we pursue other means of providing energy and protecting the environment and saving our own lives. Thank you.
Thank you, Commissioner. Commissioner Edwards.
Yes, thank you very much, Chair Howard. I will tell you that, you asked a lot of great questions. I also share your skepticism. I just have two requests. One is financial and one is environmental. So I think the staff in the joint proposal did a great job of outlining to ensure that there were going to be enough finances to complete the project. I would just like to have some reporting back to us, especially in the last phases, to ensure that there still is enough money set aside to complete the last pieces of the project, the decommissioning. Second, while I understand that the SECRA was a negative declaration because this was a financial transfer, I do want to ensure that we receive the DEC reports ongoing, especially when they make their determination and of all of the different things that have to be required, so that we can make sure that this is being done as safe as possible. With that, I thank you very much for all of your in-depth questions.
Thank you, Commissioner. Now we'll call for a vote on the item. Commissioner Berman, how do you vote?
Yes.
Commissioner Alisi, how do you vote?
Yes.
Commissioner Edwards, how do you vote?
Yes.
Thank you. I also will be voting for this item, and it is approved as presented. And thank you. Next, we'll go to our consent agenda. Do any of the commissioners wish to comment or recuse themselves from voting on any consent agenda item in this regard? Commissioner Berman.
Yes, thank you. I do wish to comment. When we look at rate cases, we do have a broad mandate to ensure that consumers receive safe and reliable utility service at reasonable rates and with the least adverse effect upon the environment. I have noted before that the Commission really stands at the crossroads of the public need for virtually essential core services and the private needs of the shareholder to ensure continued investment in these services. As such, we as the Commission really do occupy an incredibly important and unique role to balance these interests in a way that ensures the most advanced and reliable services, while at the same time ensuring they are effectively and efficiently delivered. So the critical importance of the Commission's mission is to the economic well-being of the state and its citizens, and that cannot be overstated. In a rate case, there is a formal process that is used to determine the amounts to charge customers for electricity, natural gas, private water, et cetera, provided by regulated utilities. And rate cases are a primary instrument of our regulation of these industries. We do allow interested persons to intervene and become parties in a utility company's rate case. And we do go through a process of a rate setting process where the utility company submits a filing to demonstrate the need for a rate increase. And then included in that rate filing are estimates of expenses, operating expenses, looking at labor, pension costs, materials, fuel, depreciation costs, taxes, return on investor provided capital, recognition of utility plant additions and capital expenditures. And then we have a rate setting timeline where the Department of Public Service provides a staff team that's charged with that responsibility to analyze the rate filing and represent the public interest. And administrative law judges can be assigned to preside over the case, hear all the evidence, and provide recommendations to the PSC. There are also testimony that's filed by staff, other interested groups, rebuttal testimony, hearings with cross-examination of expert witnesses. There may be an opportunity for negotiating a settlement on the issues. There's initial and reply briefs that are filed. And there are public statement hearings that are held. And then there can be additional briefs filed with the PSC. And then we, as a commission, deliberate and hold an open public meeting and decide a written order to resolve the outstanding issues and matters necessary to determine the utility company's revenue requirement and the amount to charge customers. In this case, there were 2 ALJs assigned, both were seasoned energy professionals. There were procedural technical conferences held. The ALJs identified the procedural scheduled ruling. Testimony was done. Stakeholders, in fact, some stakeholders who would normally be opposed in other rate cases supported some of the aspects of the company's proposal. There was a settlement discussion, pre-hearing conferences, rulings on schedules, the session and information sessions and public statement hearings were held. And then there was also, Corning presented a settlement offer. There was one extension given on the suspension period, which took us through May 31st. And then because there was not a further extension on the suspension period, we are here today as a special session having to decide this rate case. It is important to note that Corning initially filed the rate case on February 27th, 2020. At that time, if we adopted it in its entirety, the filing would have raised, according to Corning's filings, the average customer bills by 10.9% on a levelized basis beginning on February 1st, 2021. The time of their filing, it had been over 3.5 years since the company had come in and filed a rate case. The 3-year rate plan proposed in the case, and there were several factors that necessitated, according to the company, the increase. The two most important reasons for the increase for the company was that there were commission mandated initiatives, as well as our new decarbonization legislation, the CLCPA, resulting in companies' determination shorter plant depreciation lives, and that a higher revenue requirement was needed to cover this increased depreciation expense. According to the company, these two items comprised approximately 50% of the rate increase request, and the balance of their other request was to recover increases in health insurance, wages, and other inflationary costs. The company did plan to continue to utilize local gas production and other economic sources of gas to reduce the impact of customers. And according to the company, from an environmental and safety perspective, the company's continuing investment in pipe replacement and leak elimination has already reduced methane emissions from its system by approximately 85%. And Corning believed that the anticipated investment in replacement facilities, as reflected in their rate filing, would nearly eliminate leaks within 3 years. It's important for me to explain why I am concurring in this matter today. I have carefully weighed the issues, looking very carefully at what Corning summarized as the major drivers behind the proposed rate increase that they put forth. Of the 6.25 million rate year increase, the cost of mandated initiatives comprised about 4.5 million. Of that total, about 3.1 million was in response to legislation enacted by the state of New York, including in particular the Climate Leadership and Community Protection Act. And Corning really was focused on, and this is the largest issue, that the accelerated depreciation was necessary because the CLCPA would shorten the effective life of the company's existing and future investment in infrastructure. So that about $3.1 million increase in revenue requirement from the proposed accelerated depreciation was the largest single issue in this case, amounting to nearly half of the proposed 1-year rate increase. For me, there are things in here that I think are very good. In this order, we continue a number of positive and negative incentive mechanisms. We direct a number of measures to ensure that the company continues its leak-prone pipe replacement program at its current level, increases its effort to reduce its leak backlog, minimizes evacuation damage to its facilities, maintain its current targets for fast response times in emergencies, fully complies with pipeline safety regulations, increases its work to repair minor leaks in a flood-prone area, improves its coordination with and training of other emergency responders, and establishes a pilot program for residential methane detectors, which we have seen positive results in other utility areas. We also continue and improve the company's customer service metrics and programs to minimize complaints, achieve good results on customer satisfaction surveys, and minimize missed appointments, uncollectibles, and terminations. We also, in this order, direct an improvement to the company's outreach and education plan, approve a proposal by staff, which was accepted by the company, to eliminate fees for credit and debit card payments, and also approve a proposal by staff, also accepted by the company, to file a plan for electronic deferred payment agreements. For me, there were a couple of things that gave me pause, so I concur with reservation. This is only a 1-year rate case. Our commission has traditionally focused on multi-year rate cases. I think it's important to understand the school of thought with that. A multi-year rate case is really something that studies have shown, including from a report that was done by the Lawrence Berkeley National Laboratory, that the more often a utility takes a rate case to its utility regulator, the more its customers and performance can be negatively impacted. The report that was issued talked about more frequent rate cases are also statistically correlated with higher customer costs, and that it's not simply that customers pay the cost of regulatory proceedings, which can at times be substantial, but more significantly, according to the report, is that frequent rate cases require a utility to focus on the near term and keep it from seeing opportunities and innovation that can lead to bigger rewards over the long term for customers. The evolution of rate making in a multi-year rate case and the positive benefits of that is not something new to us in New York. We've generally supported that, but it is something that is now getting more national recognition of being an important thing to look at, especially as we get into performance-based regulation. Why is there an issue with a one-year rate case versus a multi-year rate case? Well, from the utilities perspective, there's really 6 benefits that utilities typically look at. 1, there's more predictable revenue for utilities, bolstering their financial health. 2, spreading of rate increases over a longer period. 3, more predictable rates for customers. 4, stronger performance incentives. 5, timely recovery of costs for new capital projects. And 6, fewer general rate cases over time, which helps in reducing the resources that have to go into that. From a public interest perspective, the most positive aspect of multi-year rate cases, rate plans, really seem to derive from the idea that a multi-year rate case is better able to help improve utility performance. And that goes beyond just the benefits of a utility's financial health. And there's really, again, 6 benefits that seem to come through better from a multi-year rate case. 1, it helps to enhance the utility performance by utilities able to earn its authorized rate of return, and the regulator can require the utility to improve cost efficiency over the longer term. 2, it facilitates cost recovery for capital projects and can mitigate a utility's disincentive or perceived disincentive to make socially desirable investments, and has other benefits to customers, like spreading capital cost recovery over a longer period of time than what is the traditional practice. It can mitigate rate shock. 3, an automatic rate adjustment mechanism not linked to a utility's actual cost changes can motivate it to achieve higher cost efficiency. 4, performance metrics to evaluate and take appropriate action can provide utilities with an added incentive to improve their performance and non-cost functions. 5, it gives more price flexibility and allows giving the utilities the ability to vary their price to different customers based on economic and other circumstances. And 6, it's seen as a fair share of benefits from improved utility performance between the utility and its customers can occur before the next general rate case. Also, a multi-year rate case allows us to look at potential add-ons that can be beneficial to customers, like a stay-out period, like refunds to customers, like more efficiency carryover, and better utility price flexibility, etc. Why do I point this out? Because it is really, really important for us to understand that multi-year rate cases versus one-year rate cases does matter. In this case, the one-year rate case is really trying to preserve the status quo, because we were not able to, even though throughout the order you will see that there were many synergies between the company and the staff and stakeholders, you will see that there were some issues, especially the accelerated depreciation issue, that did not make us able to come together in a joint proposal. And therefore we had to look at doing this in a one-year rate case. A one-year rate case essentially is teeing up. Shortly thereafter, there will likely be an expectation that the company will need to come back in for a new one-year rate case, as well as, since we have out there in the public sphere the fact that there is a potential acquisition of the company assets by Argo, that would likely be us having to decide the Section 70 with the new one-year rate case. So for me, I look at this as understanding that we are preserving the status quo, but that this now will directly bleed into all of us having to refocus on a very soon new one-year rate case, as well as addressing the acquisition of the company assets. So I pause because I do want to make sure that the one-year rate cases doesn't become the norm, and rather we're looking more holistically at multi-year rate cases, which traditionally for us in New York, as well as now seeing how the trend is going nationally, does seem to provide more benefits and positive reasons for us to do that. For me, I also look at some of the issues in here. We are very focused. This rate case was brought before we truly had a picture of COVID. So we are laying out in here some COVID-related austerity measures. I do take pause of that, knowing that we have the generic COVID proceeding, as well as other proceedings where some of these issues may come up. For me, I understand that at times a generic proceeding either takes place before or after in a rate case, and it doesn't always line up perfectly. Here, doing it as a one-year rate case and recognizing the COVID austerity measures, we do put in some wording in here that recognizes that when the new one-year rate case happens, some of these austerity measures may not need to be in there. I recognize that Corning did bring up that we are in a better place now with COVID, as well as from an economic perspective, but we are not out of the woods yet. And so I do think we tried to limit the austerity measures, understanding it was for this short time period, as well as knowing that we would have to address some of these issues later in the COVID generic proceeding. I think that was helpful. And I appreciated staff's diligence in those issues. The troubling aspect, and something that I think from my perspective, initially I was very concerned about, but I came to feel comfortable again in my concurrence on this, but from a cautionary perspective. Staff noted that some of the adjustments that we dealt with, especially on the austerity adjustments, were not specifically addressed during the evidentiary hearing. Staff felt, and the draft order tees up, that the commission can address these in the order because they were based on underlying commission policies. Corning was very concerned about that. I very much think generally the best course of action, especially when you are looking at a multi-year rate case, as well as looking at all the different issues, is to make sure that our traditional way of establishing a record in a rate case, frankly, in any case, is done in a way that can really have a lot of accountability and the record can be solid. So I would lean normally towards, if it's not in the traditional record and the evidentiary hearing, it is potentially improper to now seek to bring it in. That's part of the reason I concur rather than fully voting for it. It's cautionary to me that this language in this draft order not be misinterpreted, that we can always bring into a rate case things that were not in the record and specifically addressed during the evidentiary hearing and the necessary testimony, et cetera. It's really, really important that folks understand this is limited in our scope and also in the impact that this might have in other rate cases, and not be a get a free pass to not make sure that your record is really strong. In fact, it needs to be. The other issue that I think is important, at least from my perspective, is noting that we looked at the amortization issues, and we, in the order, it finds after staff suggests that we should amortize all new deferrals over 10 years to reduce the revenue requirement. The order finds an appropriate balance between the competing concerns that were expressed over this issue, and that it can be struck by amortizing all deferred regulatory assets, including both pension and other post-employment benefit amounts over a 10-year period, and amortizing all deferred regulatory liabilities other than the OPEB deferral over a 3-year period. The intention behind this is to reduce the increase in the company's revenue requirement. And these measures, along with the other austerity measures that are in the order, are intended to mitigate the increase in the company's revenue requirement, and thereby would protect the interest of ratepayers in the context of the still ongoing COVID-19 pandemic. So accordingly, we essentially delay the company's collection of its regulatory assets as a means of mitigating the revenue requirement increase, and the rate case expenses will be amortized over 10 years, and that's consistent with the other deferral assets. I take pause on that. I am concerned about that. I'm concerned about what that may mean from a bond rating perspective, as well as what it may cost and other potential harm on the ability to attract capital and borrow capital at a low cost. So I will be looking carefully at that and what may happen. However, I recognize that here we were also looking at a straight 1-year rate case and trying to not overburden the ratepayers and needing to look at how to defer that. But in the new rate case, and also with a potential acquisition of a new owner, these issues will be able to be fleshed out more, and what the new owner may do in terms of that, it can be accounted for in any potential acquisition of the company assets in that. I think that the order tries to strike a very thoughtful balance on the acceleration depreciation issues. I think it's well worth everyone's reading of the detailed language that's in the order. I will not read it now for expediency purposes, but I will point out that there are real concerns here with what this may mean for the implementation of the CLCPA. Now, the company argues that the CLCPA mandates that mandate the reduction of statewide greenhouse gas emissions by 85% of 1990 levels by 2050, that statute effectively shortens the effective life of the company's existing and future investment in infrastructure, and talks about the essential increase and cost that will have. The impact of that CLCPA on the costs when implemented is really important for us to get a handle on. There are other proceedings not only at the commission, but elsewhere that are really looking at this. We really do need to get under the hood on all of those aspects. I did take to heart UIU's position that the CLCPA does not explicitly state that all gas assets will be retired by 2050, nor has it been determined what role, if any, pipeline infrastructure will play in reaching the CLCPA's goals. I think that there is no disagreement that the costs to do this will be potentially significant. The implementation of the CLCPA by the commission will be difficult, complicated, and potentially, in my mind, extremely expensive. And we will need to fully understand that, as well as ensure that we are properly managing the oversight of the grid from a reliability perspective. And I do agree with UIU that the CLCPA is not a no gas statute, though some may interpret it that way. And it is for us to work through that, but not in this one-year rate case. And therefore, those issues were not decided here, and we backed out some of the requests that dealt with that huge increase, which allowed us to come for this one-year rate case that was not as harsh on the increase from the ratepayers. With all of that, I do want to thank the staff and the ALJs who worked on these issues. I also want to focus on the fact that going into a new rate case, I think there are a lot of lessons that can be learned across the board, and also some positive conversation as appropriate that can happen with the company, staff, and the other interested parties in the rate case. Again, I do point out that there was a lot of synergies, and folks were just not able to get there in the limited time fashion that dictated that we would have to vote on this item without the extension of that suspension period. So with that, I will be concurring. I thank you for allowing me the opportunity to speak on this issue, because it's very important to me. So thank you.
Thank you, Commissioner Berman. Commissioner Alisi.
Thank you, Mr. Chairman. I have no comments. I'll be supporting it.
Thank you, Commissioner Berman.
Commissioner Edwards here.
Or excuse me, Commissioner Edwards, I apologize.
That's okay. I have no comments. Thank you, Chair.
Great. With that being said, I will call for a vote. Commissioner Berman, how do you vote?
I concur.
Thank you. Commissioner Alisi.
Yes.
Commissioner Edwards. Commissioner Edwards?
Can you hear me? Yes.
Thank you very much. Thank you.
Chair, for good order's sake, could you please state your vote?
Oh, excuse me. I'm sorry. I will be voting yes on the item. Thank you. Again, I apologize for breaking somewhat of the stride here, but when one goes through a list of people to acknowledge, it's always hard because you're going to miss somebody. And regarding our Indian Point initiative, I also want to thank some other Fed partner agencies at NYSERDA, Janice Dean and Elise Peterson, and at DISH's, Alicia and Comco. Again, thank you for your help. Commissioner Phillips, Secretary Phillips, pardon me. Are there any more items to come before us today?
There are no more items to come before you.
Thank you. With that, I will adjourn this meeting. Thank you very much.